Chapter 14 was about intellectual property, and it's defined as the fruit of one's mind. The laws of intellectual property protect property that is primarily the result of mental creativity rather than physical effort. This category includes trademarks, patents, trade secrets, and copyrights. A trademark is defined as a distinctive mark, a wood design, picture, or arrangement used by a seller in conjunction with the product that tends to cause the consumer to identify the product with the producer. Types of marks that are protected, color, and even a scent are unique to serve to identify their source. They can be trademarked, they can be registered, and therefore recover any damages from the mark if they occur. Then it talks about trade dress, the overall appearance and image of a product that has acquired secondary meaning. To succeed on a claim of trademark infringement, a party must prove three things. The trade dress is primarily non-functional, it is inherently distinctive or has acquired a secondary meaning, and the alleged infringement creates a likelihood of confusion. The main focus of a case of trade dress infringement is usually on whether or not there is likely to be consumer confusion. A claim of trade dress infringement is often accompanied by a claim of trademark infringement. Then they talk about patents. Grants the holder the exclusive right to produce, sell, and use a product, process the invention. The criteria for a patent: it needs to be novel, useful, and non-obvious. They also talked about cross-licensing, trade secrets. A trade secret is a process, product, or method of operation or compilation of information used in a business that is not known to the public and may be best as a competitive advantage on the business. A trade secret that exists. Then they talk about copyright, the exclusive legal right to reproduce, publish, and sell the fixed form of an expression of an original creative idea. Criteria for it to be a copyright is it must be original, it must be creative, and it must be fixed, which means set out in a tangible medium of expression. They also talked about fair use doctrine, which is a legal doctrine providing that a portion of the copyrighted work may be reproduced for purposes of criticism, comment, news reporting, or teaching, including having multiple copies for classroom use, scholarships, and research. Copyrights in the digital age, software, and copyrights of the 1976 No Electronic Theft Act of 1997 talked about Digital Millennium Copyright Act file sharing networks and technologies, and these were all there to protect. Chapter 15 goes into discussing agency law. An agency is defined as a fiduciary relationship between two persons in which one, the agent, acts on behalf of the other, which is the principal. The principal is defined as having the agent relationship, which is the relationship in which the principal gives the agent express or actual authority to act on the former's behalf. Expressed authority is authority that arises from specific statements made by the principal or the employer to the agent, which is the employee. Actual authority includes expressed authority as well as implied authority, or that authority customarily given to an agent in an industry, a trade, or a profession. They covered respondent superior, which is a legal doctrine, and then they talked about employer-employee relationship, a relationship in which the employee or the agent works for pay and is subject to the control of the principal, which is the employer, may enter into contractual relationship on the latter's behalf. Then they go further into detail about employer-independent contractor relationship, where you have a relationship with the agent or an independent contractor is hired by the employer to do a specific job and is evaluated on their work performance, expressed agency by agreement, agency relationship formed through an oral or written agreement. Power of attorney, I was familiar with this term, an agency agreement used to give an agent authority to sign legal documents on behalf of the principal. I know I had multiple conversations with my father before he passed as to whether or not he had a power of attorney, and he ended up not having one. And the law stated that since he was married, that my mother was in control of everything. So everything just went to her and she made all the decisions. Agency implied authority is agency relationship in which customs and circumstances rather than a detailed formal agreement determine the agent's authority, whether they receive payments of money due to the principal, enter into contracts for incidentals, employer discharge employees, buy equipment and supplies. There is agency by ratification, talked about estoppel, agency by estoppel, which is a parent authority agency relationship in which the principal is estopped from denying that someone is the principal's agent after leading a third party to believe that the person is an agent. The principal is the employer, and they owe 4 duties to an agent, which is the employee: a duty of compensation, a duty of reimbursement and indemnification, a duty of cooperation, and a duty to provide a safe working environment. The duties are part of a written contract or implied by law. Contingency fee is the agent's compensation that consists of percentage of the amounts the agent secured for the principal in a business transaction. Indemnity is the obligation of the principal to reimburse the agent for any losses that incur while acting on the principal's behalf. There is a duty of obedience. The agent has the duty to follow all reasonable and lawful instructions of the principal. There's a duty of accounting, duty of performance. They have contractual liability. They talked about disclosed principal, which is one whose identity is known by the third party when the latter enters into an agreement negotiated by the agent. Partially disclosed principal is one whose identity is not known to the third party at the time of the agreement. The undisclosed principal is one whose identity and existence are unknown to the third party. And then finally, they went in to talk about joint and several liability, the legal principle that makes 2 or more people liable for a judgment, either as individuals or in any proportional combination. As far as my personal experience, what I've been through or what I may encounter and what I may take from these chapters, as an employee, I have went into a somewhat of a contractual agreement with my employer. They definitely have rules and regulations that I have to follow, and if certain things aren't being done within that contract, they do bring it to your attention, whether it be verbally or written, and they do have you sign off on those things, and with the understanding that if changes aren't made, then further action may be taken. So I am familiar with those, and it is important to have the contracts written and available to the employee from the employer, so that way there is a clear definition as to what they expect of you as their employee.